All right, I'm going to call the meeting of the Sentencing Guidelines Commission to order. It is, oh, I'm going to be back from somewhere. Got it?
Yeah, I got it.
All right, calling the meeting of the Sentencing Guidelines Commission to order. It's Thursday, April 11th, 2024. I'm going to ask our director, Nate Reitz, to go ahead and read the roll.
Roll call. Vice Chair Larkin.
Present.
Larkin present. Commissioner Crutchfield. Crutchfield absent. Fraze. Fraze absent. Knutson.
Present.
Knutson present. Ladd.
Present.
Ladd present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore absent. Morin. I'm sorry, wait.
I think that was
Oh, Morath. I'm sorry, Morath.
present.
Morath present. Morin.
Present.
Morin present. Mueller.
Present.
Mueller present. Reeves.
Present.
Reeves present. Saxena.
Present.
Saxena present. Chair Mitchell.
Present.
Chair Mitchell present. Just going to confirm the absence of Crutchfield, Fraze, and Moore. Is that correct? Not hearing any response, Madam Chair. There are 10 members present, 3 members absent.
Okay, and with that, we have a quorum. First item on the agenda is approval of the draft meeting agenda. I'll entertain a motion to approve the agenda.
So moved.
Commissioner Reeves makes that motion. Do we have a second? Second. Second by Commissioner Larkin. Any discussion on the agenda? Hearing none, we'll take the vote.
To the Reeves motion to adopt the agenda, Larkin.
Yes.
Larkin, yes. Crutchfield. Crutchfield absent. Fraze. Fraze absent. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore. Moore absent. Morath.
Yes.
Morath, yes. Morin.
Yes.
Morin, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena. Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the agenda is approved unanimously. Motion's approved unanimously. Next item is approval of the draft meeting minutes from March 7th, 2024. These were sent out a week ago, so you should have all had an opportunity to review them. I will entertain a motion to approve the minutes. Commissioner Middlebrook makes that motion. Do we have a second? Second. Commissioner Larkin seconds. Any discussion on the minutes? Hearing none, we'll take the vote.
To the Middlebrook motion to approve the March 7th minutes, Larkin.
Yes.
Larkin, yes. Crutchfield. Crutchfield absent. Fraze. Fraze absent. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore. Moore absent. Morath.
Yes.
Morath, yes. Morin.
Yes.
Morin, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena.
Yes.
Saxena, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item on the agenda is the Veterans Sentencing Data Bill. I'm going to invite Representative Weens to the front here to tell us a little bit about the bill and what you'd like the commission to consider. Well, welcome to the Sentencing Guidelines Commission.
Thank you, Madam Chair, and thank you, board members, and also staff. And thank you for considering the Sentencing Guideline Commission report. Just by way of describing kind of how we got to this point, about 15 years ago, the concept of the Veterans Treatment Court came about. Hennepin County, Ramsey County, many counties and judicial districts have adopted a Veterans Treatment Court, and it's pretty well established. It has metrics. It plugs into the VA, the state VA, as well as the federal VA, which provides the assistance to those veterans who are suffering. And typically, the veteran is a veteran that's suffering from either post-traumatic stress, military sexual trauma, or minor traumatic brain injury. And there's a service connection to either substance abuse or a mental health issue. Sometimes they're combined. And bringing all those assets together is good for the veteran as well as it's good for the community. And it provides a safety aspect. Last year, we passed the Veterans Restorative Justice Act. And that act really is a gap filler for those communities, counties, judicial districts that have not yet adopted a Veterans Treatment Court and has the same criteria by which veterans are able to get assistance and connected to the VA for those particular issues to make certain that we restore them to their family and their community as we've made a commitment to the veterans, as well as providing safety to communities. So that bill was passed, but it did not have the reporting metrics that the Veterans Treatment Court has had over the past 14 years. So my effort here, and it's a bipartisan effort with the author of the VRJA, we sat down, discussed this, and we thought piggybacking on the Veterans Treatment Court reporting pieces and using that same process to provide a committee report back. So it really requires two reports. First, it requires the courts to take the process of all these veterans, provide the definitive data to the Sentencing Guidelines Commission, and the Sentencing Guidelines Commission will then depersonalize that information. So it's more of a raw data numbers report back to two committees in the legislature, the Public Safety as well as the Veterans Committee. From there, we'll take a look at that and use that to determine if the program is on track. The key thing here is that we have accountability, transparency, and effectiveness in our commitment to our veterans, our communities, and our legal system. So at this time, I will ask for, I guess, any questions, if you have questions.
Does anyone on the commission have questions?
Madam Chair,
Commissioner Knudsen?
I walked in and met the representative, and I had a ton of questions, and he answered them all.
Well, you should ask them again.
30 years of military experience is like, thank you. Those were really good questions, Judge. And I appreciate you asking those because you know, as we take a look in public service and in government, I think our citizens really want to know that they can trust what we say and what we do, and that we've researched it, and that it's effective. And that's really what I'm trying to do here, and what I think you guys are trying to do in the Sentencing Guidelines Commission. I appreciate the opportunity. And one thing I did not mention. The courts came back, and the fiscal note it doesn't cost anything because it's a similar report. And my understanding is it's probably also a fiscal note of zero from the Sentencing Guidelines Commission.
And just so you know what I was asking him was why all this detailed information then when you want to synthesize it down and just then be provided the summary information, and then the commission has to do that. Why isn't the courts just getting that summary information? But it seems in our discussion, I think from the court's perspective, they don't want to burden the courts either. But I think we talked about it, that they're probably already gathering that individual specific information that's listed in the first part of the bill. And so what Representative's asking for is just a summary aggregate information without getting all that detail, and then apparently the commission can do it easily without any cost. So.
Madam Chair,
Director Rice?
thank you. Yes, that's correct, Commissioner Knudsen. We do anticipate that we can absorb the costs of this reporting.
Commissioner Middlebrook and then Commissioner Platt.
Thank you, Madam Chair. I know this is a part of this, understand that this bill is for the reporting, but do you have any numbers from the last couple years? Is there any numbers out there on how many cases there would be getting this information?
So we just passed the VRJA last year.
Last year.
And there's 64
Okay.
cases that are in process. And again, not to go into too much detail, but if we take the Veterans Treatment Court kind of data, it takes about 2 years for the average veteran to go through all the different steps in that recovery treatment process from your analysis. And it's a step process, and it's some people have issues and then they have to repeat a step. The fastest folks that go through it takes about 1.5 years. So this will take us, I think another year to really see people that are progressing through the process to make certain that we are doing what we have committed to our veterans and to our communities.
Understand, thanks.
Thank you.
Commissioner Latt.
Thank you. My question is obviously more on process side as well, separate and apart from guidelines. When I was looking at the bill, I'm one of those counties that doesn't have any kind of specialty court. So I appreciate sort of when language can be found in a statute that allows us to utilize these diversion tactics, if you will. Yeah. But one of the things I was looking at here, because I hear this a lot when I'm in court, and a lot of times there's not definitions around it. But under paragraph number 3 of the bill, it says whether the violation was a technical violation. We hear that a lot. That particular statute that's in there is actually a repealed statute. So I was curious about what does that, I'm wondering what a technical violation is, just in just sort of reading through that, if you know.
And I will have to say that there is an amendment for a couple of things that Mr. Wrights pointed out to me. It was originally drafted in 23, and it was just passed through the Senate and the House and going to the General Register, and we discovered that there's a couple of obsolete references.
Okay.
But a technical violation, to my understanding, is where there's the paperwork has not satisfied the legal requirement. And then we have to go back and take a look at the process.
So that will actually end up being defined somewhere what a technical violation is.
Yes, ma'am.
Okay, thank you.
And if I can mention, my county does not have a classic veterans treatment court, but it does have its own diversion process where it does have a kind of we call it, Washington County calls it a veterans treatment court. And it does work very similar, but it is not part of the state's veteran, recognized as the state's veteran treatment court. So this would be applicable to those counties then, again, getting those assets to the needy veterans as well as the counties that want to have a process.
Thank you. Commissioner Mueller, you have a question?
It's not a question, just really a comment in support of the work that Representative Weems is doing. You mentioned Washington County and the work that we're doing out here, but in terms of law enforcement perspective, we're absolutely in favor of this work. This work was started by, in Washington County by County Attorney Pete Orpett, and Representative Weems just, kind of carrying it on throughout the state. So through that lens, absolutely in support of the work that he's doing, and just grateful that you're doing that. So thank you, Representative.
Thank you, Chief. And I didn't mention Pete Orpett, who started the first Veterans Treatment Court in Hennepin County, and then when he came to Washington County, set up the court that's currently operating there. So thanks again, Chief.
Any other comments or questions? Well, I like to raise questions, but I don't have a solution for it. The only thing that strikes me about the bill is, so the Sentencing Commission only collects conviction information. So you have to have been convicted of a crime, and that's the data that we normally get, and this is based on deferred prosecution, right? So it happens ahead of that conviction. So the only concern I have is we might miss some, because if somebody fails to send us the report, we would have to devise a way to understand when that's happening, because we wouldn't catch it in our normal data flow if they never get to a conviction, right? Like with the departure report, we know when we don't get one because we we've got a conviction, we have a sentence that doesn't match the guidelines, and we don't have a departure report, so we have that natural data check there. So that was the only thing that stood out to me about this one was, what's our check and balance to make sure that we would get the information to be able to report accurately.
Madam Chair, I'll take that as a due out, as a request for information. I'll get back to you on that.
Okay. Any other questions or comments? So as I understand it, you were wondering if we would be interested in actually supporting the bill. Am I correct on that?
That would be my request, but as I guess I found out with the courts, the courts have remained silent. They have not spoken against it. They have not spoken for it, although we have dialogued in the development of this process. So if you would take a vote and approve it, I would be ecstatic. But I understand that possibly that is not what will happen today.
Okay. What's the will of the commission?
Well, we're a little more nimble at the commission. I share the court's legislative proposal stuff. That needed to start back last August to get
Yes, sir.
wound through and approved and all that stuff. I think we could support it.
We have in the past. We have supported bills in the past. It's not that we never do it. So it's really up to the commission. If somebody is interested in doing that, someone would need to bring a motion, and we would have, and then we could vote on it.
So move, Madam Chair.
Commissioner Knudsen votes to support the bill. Do we have a second?
Second.
Second
Mueller
from
seconds.
Commissioner Middlebrook I saw first. So we'll go with that. But there were lots of seconds, so that's good. All right, any discussion on the motion? Hearing none, we can take a vote. Oh, and we should recognize that Commissioner Moore is present.
And Commissioner Free.
Oh, and Commissioner Freeze, yes.
Second was Middlebrook.
Yes.
Okay. So to the Knudsen motion that the Minnesota Sentencing Guidelines Commission support House File 3304. Larkin?
Yes.
Larkin, yes. Crutchfield? Crutchfield absent. Phrase?
Aye.
Phrase, yes. Knudsen?
Yes.
Knudsen, yes. Ladd?
Yes.
Ladd, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Morath?
Yes.
Morath, yes. Moran?
Yes.
Moran, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Thanks for bringing this to our attention, and good luck at the legislature.
Thank you, Madam Chair, and thank you, Commission, for your support. Look forward to working with you in the future.
Great, sounds good.
Thanks.
Thank you.
All right. I lost my agenda. Oh, here we go. All right, so the next item on the agenda is an update from the University of Minnesota research team. Not sure who's taking that. Is that Chris Egan, or I saw Julia Laskowski online?
Julia.
Julia? Okay, so Julia.
Everyone can hear me?
Yes, we can.
Okay. So I'll be doing a short presentation today, and then we have some time for discussion. I believe both Chris and Kevin are there to also answer questions.
That's correct.
Can you remind me, do I just share my screen here?
Yeah, so there should be a share button, and then it'll give you the option to either share an application or share a screen, your choice.
So we can see it. It's just not in presentation.
Not in presenter view.
Yeah. Yeah, you got it.
Okay.
There we go.
Perfect.
Okay. Let me just make sure I can, okay. Okay, so this is going to be a pretty short presentation for those of you who have not met me yet. My name is Julia Laskrinsky. I'm a research director at the University of Minnesota's Robina Institute. We are partnered with the commission to provide research support over the course of the comprehensive review. This is our, I believe, our 4th or 5th time being back, and for now it'll be our shortest. But just to give you a little bit of a recap, during the February 8th meeting, we had a very good discussion. We provided a broad overview of how our research partnership would work. We sketched a menu of possible research projects. And then after that, we met as a team, as a research team, and did some preliminary inquiries and discussed the degree of difficulty of the research projects. You guys gave us a lot of ideas. It was a very rich discussion. We had a lot of options to choose from and a lot of things to discuss. And then Chris, you came to your last meeting to present and try to just narrow down some of the research ideas that everybody came up with, and also just provide an overview of the feasibility of some of them. So he presented some detailed research areas and approaches for the upcoming 2-year grant, and you also prioritize some of your interests. So I am back today, again, fairly briefly, to give you an overview of the topics we plan to pursue over the course of this grant. So when we are establishing a research agenda, we really looked at a few factors. The first factor, of course, is this of interest to the commission? That's really the underlying factor for all of these research inquiries. But we also had a few others, and a few others are, as Chris mentioned last time, the feasibility. Do we have the time to get a study like this done, to answer this research question? Do we have the data to access it? For a lot of some of these big open questions, that the answer was no, not right now, but possibly in the future as we pursue some additional funding after this grant ends. Also, is this of interest to the research team? This is a research team that has a specific level of expertise. It has some experience with some of these prior research questions, and so we wanted to focus on the things we knew we could get done quickly and get done really well at a high level. And then finally, the last point is probably one that that I think is particularly important, and it's actionability. You know, what we promise to you all and what we promise to our funders is to produce research that you can act on. So are you going to be able to act on the research that we give you, on the information that we give to you? Because overall, the goal of this research partnership is we want to produce research that supports your decision making. So with that being said, the first research area that we're going to focus on is to, some of these are kind of still bigger open questions, and underneath are some smaller, more focused questions that we're going to pursue. But I'll cover the 4 big buckets we're going to cover. So I think the fundamental and a really like a foundational question for this type of research is, why is the presumptive prison rate increasing over time? This is something that your staff has already identified. It really is an important question that's going to set the basis for a lot of other questions that we plan to pursue. There are several factors that have been contributing to this that your staff has already identified that we assume are contributing. These are things like the effect of mandatory minimum sentences, the creation of new felony offenses, and also a big part of this links up to any questions about the criminal history score. We already know the criminal history score, the average criminal history score is increasing. That is probably feeding into the increase in the presumptive prison rate over time. And that leads to a lot of other questions. Why has the criminal history score gone up? And what is it doing specifically? Is it pushing lower, medium level offense severity cases over the dispositional line? So we plan to give you some more information about that. So the other bucket is one we've been hearing from you in kind of various in various ways, but largely it's how to choose the right sentence for the right offender. And this is a very large bucket because there are a lot of smaller research questions that kind of go into it. But some of the questions that we can pursue in this bucket would be, how do guideline values set by the commission affect outcomes? More specifically, what have been the effects of specific policy changes? And how have they affected outcomes? And also, possibly just as importantly, doing that kind of legal and policy analysis research to figure out what were the intended effects of those policy changes, and did those effects come to fruition, and were there some unintended effects? And I'm talking about things like large durational increases and higher severity levels, the adoption of new grids. And so some other questions we can pursue in this area are what could be the potential consequences of moving the dispositional line, and also what is the effect of departures on public safety? We have a little bit more of a departure focus in another bucket, but this question kind of stands on its own because it really looks at, more specifically, what is the effect of a sentence, right, on the outcomes of a case, of an outcomes of a person's trajectory. So when a departure happens, what does it affect downline? The third bucket that we plan to look at is very high departure rates on specific offenses. We do plan to look at whether there has been an increase in the departure rate overall historically, and I think there has. But really more specifically to delve into the very specific, I believe it's 5 or 6 offenses that have extremely high departure rates, some over 50%. And some of them have both dispositional and durational departure rates. That's really something that is directly actionable by the committee. And I think we can provide information on how to take action on it if you so choose. We can provide information on how large the departures are, what offense case or individual level factors lead to these departures. And also we can, and those are more quantitative, we can also provide more general information about how decisions around departures are made. So doing some more qualitative work on, for example, prosecutorial and judicial attitudes towards the guidelines, towards decision-making, how they view criminal history, how they view severity, that you really can't answer with quantitative data, but you can definitely answer with some qualitative data. And finally, we are going to look at, there's going to be a comparative component to all this. How do the commission's policies, statutes, and guidelines compare to other sentencing commissions? For example, how do commissions define the purpose of sentencing? How do commissions define public safety? And then how does Minnesota's use of prison, jails, and probation compare to other states? That's going to be, this comparative aspect is going to underline these, like all of our research questions, but I think more specifically, we're definitely going to be looking at what other, how other guidelines are functioning and how other commissions are doing their work to provide more information to you. And so our research approach is really, we're going to produce some quantitative data analysis. We are already well on the way with that, thanks to excellent record keeping that you have, as well as the assistance of your staff. So we're going to use Administrative Sentencing Commission and courts data. We may link it up to to some other news release data, but the details of that, we're still trying to figure that out. And so we'll be able to ID trends and patterns. We'll be able to establish quantitative relationships between factors and evaluate impact of policies. We're also going to do some qualitative data analysis, mainly thematic analysis of interview data with decision makers. This would be mainly judges and prosecutors, possibly defense attorneys. And we could develop a process model of how judges arrive at a sentence, how they choose a sentence. There's going to also be a legal and policy analysis section. And really, this is incredibly important because in order to answer any of these questions well, you really need to establish a legal and policy roadmap of how commission policies have evolved over time. And so we think that will be, that's also well underway. And I think that will be very useful, not just for this research project, but any future research projects you choose to pursue. We are going to give you some short-term deliverables, probably starting this year. Research and policy briefs, we'll come back and do presentations. And then we do plan to have some longer deliverables, long-term deliverables that you probably won't see until next year. And these are going to be longer research reports where we have a lot more of an involved approach with policy implications and history and things like that. So during that time, we will continuously update you on our research projects. We're not going to come back every single time, but we will definitely we'll definitely update you on our progress every few months or so. And then we are also open and available to respond to timely research questions or policy questions that you may have if something comes up, particularly if it's in response to a topic we're already working on and there is something that you have a very specific question about. We would be more than happy to produce a research brief or just come in and talk about whatever topic it is that you decide would be helpful to you. With that is all I have for today. I'd love to hear any feedback or your thoughts on this.
Thank you. I really appreciate the way that you've laid that out. I think you've brought a lot of organization to a ton of thoughts that we've had over the past couple of months. I think it's a pretty good list. It's impressive. Other feedback or questions from commission members? Commissioner Knudsen.
Going back to bucket number 2, can you get that answer as soon as possible?
Which part of bucket number 2?
All of it.
All of it.
So has that question been asked before or studied before? I got to believe somewhere along the line, but that's kind of, for me, that's the whole nut.
It is that is the most important bucket. We have talked about doing some, some incremental research, right? So, I mean, there are different types of research, and one of the things that takes a long time is getting data, doing the analysis, and kind of putting everything into context and writing it up. What we can do fairly quickly is look at past research and what we already know, and then doing some very, very quick preliminary analysis. That's not going to give you the full answer to the questions that you're probably looking for, but we can certainly we can provide some information quicker, if that makes sense. I don't know if Chris or Kevin wanted to jump in there.
I think Commissioner Knudsen is actually Judge Knudsen, who sits on a bench every day and has to sentence people. So I think he's looking for an answer tomorrow about how to choose the right sentence, right?
Yeah, it's partially kidding, of course, but I think I'd love seeing that bucket number 2. That's really encouraging, just to see that we're going to be looking at that.
Other questions or feedback? Commissioner Ladd.
Is there any way that we could get a copy of those slides?
I will be asking Dr. Laskrensky for the slides and presenting them to you afterwards, yes.
Thank you.
Other questions or feedback? All right. Well, thank you so much. It's very exciting to see the end product, and we're really looking forward to seeing some of these pieces come back to us.
Thanks for having me.
All right. All right, and so we'll move on to the next item on our agenda, which is history of sentencing guidelines, purpose and principles. And I think that you're being the director, right?
I am, Madam
About
Chair.
that? Okay.
Yes. So this is, I was joking around before the meeting. This is kind of like the umpteenth time we've said, okay, now we're really starting the comprehensive review. But I feel like this is, in some sense, starting the comprehensive review. Although I will say, so looking at the purposes and principles made sense to me originally as the right place to start, because it's kind of foundational for how you think about the guidelines as you're going through the rest of your decisions. And it's the first thing that's listed in the sentencing guidelines, so it just kind of made sense. Although as I was preparing this paper, I read about from the Parent book, Dale Parent, the first executive director, talking about how the 1978-79 Commission came up with the sentencing guidelines. And they didn't really come up with it, as we'll see, just desserts as being sort of the core principle around which they designed the sentencing guidelines. They didn't come up with that right away. That wasn't the first thing they talked about. They talked about many other things, and sort of eventually there came to be a consensus that that was what the purpose of the sentencing guidelines should be. So that's, I guess, one caveat. The other caveat, and we saw in Dr. Lesa Kerensky's presentation that she's looking at what is the purpose of sentencing. It's not really what this is about. This is about the purpose of the sentencing guidelines, which may or may not be the same thing as the purpose of sentencing. And the third thing I wanted to just say is, as far as a caveat, is this is pretty narrow. We're not talking about, entirely what should be the purpose and principles of the sentencing guidelines, but really we're just looking, A, historically, and B, at Minnesota. So we'll definitely be continuing this discussion later on with a broader look, but I thought this made sense as a place to start. It's information we have available to us. We can see what historically the purpose and principles of the sentencing guidelines have been as they were developed. So this paper looks at this in two parts. One is how was this historically guided by the legislature, the purpose and principles of the sentencing guidelines, and second, how did the commission interpret the purposes and principles? Or purpose and principles. I guess that's usually singular, so I mostly refer to it as one purpose and perhaps multiple principles. Although I don't really take a lot of ink in distinguishing the two in this paper. So the Minnesota Sentencing Guidelines Commission was established in 1978. The charter statute, Minnesota Statute 24409, still on the books, still our charter statute, and really very similar in many, many ways to how it appeared in 1978 when it was drafted. Minnesota Sentencing Guidelines Commission was kicked off in, I think, May or June of 1978. People started filling the positions that were established, and it was the nation's first Sentencing Guidelines Commission. Amazingly, their task was to turn around sentencing guidelines by January 1st of 1980. So they had about a year and a half to create the first sentencing guidelines in the nation. And so we'll talk about the really subdivision 5 of Minnesota Statute 24409, which is largely the same in 2023, 2024 as it was in 1978. And so what we have here in table 1, the middle column, the main column is the current text of it, of subdivision 5. There is a final paragraph that I'm omitting here that just has to do with rulemaking and some things that are within Commissioner Knudsen's subcommittee's jurisdiction that he's currently working on rulemaking, but that really doesn't have anything to do with purpose and principles, so we've omitted that. And there are two colors of highlighting in this. Yellow is talking about a change over time. So it's just kind of alerting you to language that's in there now that maybe something was taken out or something was added over time. So it's something that's different than the 1978 version. And blue is where we're inferring something about a purpose or principle in there. So, or turquoise, I guess. So that's that highlight. So the big thing that I want to, really one of the first things that I want to highlight in terms of yellow. So I'm going to jump down to this this almost entirely yellow paragraph here. Well, no, I'm sorry, going to go down below that. So in establishing the sentencing guidelines, the commission shall consider. So let's look at that paragraph there. So it's at the bottom of page 2 of this document. So it didn't used to say the primary consideration of the commission shall be public safety. So the sentence used to read, in establishing the sentencing guidelines, the commission shall take into substantial consideration current sentencing and release practices, correctional resources, including but not limited to capacities of state and local correctional resources. But in 1988, the commission added this language here: the primary consideration of the commission shall be public safety, and then changed take into substantial consideration to consider. So arguably that was the biggest change, and that was the first change that the legislature made in 1988, the biggest change to the statute. And then in 1996, the legislature added another consideration, the long-term negative impact of crime on the community. In 1997, the legislature added this entire new paragraph here, a clarifying paragraph that really talks about several purposes or principles of sentencing guidelines. And those are really the biggest changes. There's also a change here in the upper range, I think really in response to Blakely. But as far as purposes and principles, so here's what we inferred from all these. So the guidelines shall be based on reasonable offense and offender characteristics. And down a little bit farther, it says based on a reasonable or based on appropriate combination of reasonable offense and offender characteristics. Also talks about being proper, that the circumstances under which imprisonment of an offender is proper. Talks about proper. So we get from that inferred principles of reasonableness, propriety, and appropriateness. I guess propriety and appropriateness, maybe that's the same root word, so maybe those are the same. And then in this new paragraph that was added in 1997, we have, they kind of spell it out for us here. They talk about uniformity, proportionality, rationality, and predictability. We already talked about public safety. That was the one added in 1988. And then the other ones that were previously there: consistency with current practice, correctional resources and capacity, and community impact from crime. So we kind of summarize those in 5 different categories. There's the idea of rationality in the statute, the idea of proportionality. So rationality, reasonableness, proportionality, which maybe is the one that's most related to just desserts, you know, that the punishment fits the crime. We'll be talking about just desserts here in just a minute. Proportionality, related propriety, appropriateness, uniformity, predictability, consistency with current practice, those relate to uniformity. Public safety.
May I have your attention, please? The tornado drill has been activated. Please immediately by stairway
All right, we're
to the training academy basement hallway.
pausing for a moment for those online because there is a tornado.
May I have your attention,
We
please?
did discuss
The
this
tornado
for
drill
those in the
has
room
been
before the meeting.
activated.
I believe the
Proceed
chair's
immediately by
decision is to
stairway to
proceed
the training
with the
academy
tornado
basement
drill,
hallway. Again,
authorized to do
this
by
is
the
the drill.
building administration. So, you know, community impact from crime and public safety are related, and then correctional resources and capacity. So that's kind of a summary of what the charter statute says and what it has said over time. And then we've got the sentencing guidelines restatement of its purposes and principles. And this is, there's a lot of echo in here. Some of these have been added over time. Some of those changes were actually fairly recent. So it talks about promoting public safety, and the number one principle now being establishing and modifying the sentencing guidelines. The commissioner's primary consideration should be public safety, and it also talks about the long-term negative impact of crime on the community. Interestingly, that was added in 1988, and the commission didn't change that. They didn't actually sort of acknowledge at least formally in the guidelines, didn't acknowledge that as being a principle of the sentencing guidelines until, I guess, fairly recently. I don't remember exactly when, but it was since I've been here, so within the last decade for sure. It talks about rationality, it talks about correctional resources and so forth. There are other references to purpose and principles within the sentencing guidelines. In section 2D2, it talks about how race, sex, socioeconomic factors, the exercise of constitutional right, and consideration of circumstances that would be the elements of another offense. Those are not proper sentencing considerations. Sections 3A and 3B contain a number of advisory principles for courts to consider when establishing the conditions of probation, deciding whether to revoke probation. And then there's some fairly new language in section 2B, 2E, and a comment to that draws the sentencing court's attention for the purpose of waiving a custody status point. So this is something that was just added to the sentencing guidelines fairly recently, that the court could waive custody status in certain circumstances. And this is where the traditional purposes of sentencing are mentioned, which are retribution, incapacitation, deterrence, restitution, and rehabilitation, which is I think super interesting, especially in light of the First Commission's focus on really retribution, which we'll talk about in a minute. And then there is also a definition of public safety in that context, which is protecting the public from crime, which is also interesting and perhaps controversial. We heard from Professor Reitz in January talking about the model penal code, and it also has competing views on what is public safety and so forth. So it's definitely not a no-brainer as to what exactly public safety means. And then the next section I found the most interesting when I was writing this paper, and I will say I should acknowledge, I'm going to pause for a moment, and this is really going to be part of my executive director's report, but I want to acknowledge we have, we were told last month that we would have some new employees working with us this time, and in fact we do, so I'd just like to introduce them. Devontae Roche is, if you just wave your hand, so he's our new permanent research analyst. So that's our permanent position, sitting to Leah's right, and then sitting to Leah's left is Matt Helina. Now, Matt is our temporary research analyst intermediate. So his focus is really going to be helping us with the comprehensive review research. We're really hoping that he can integrate with the University of Minnesota team and kind of be both assist them and be the liaison for them. So they're still in the training process, but part of Matt's training was to read Dale Parent's book. So I not one to pass up an opportunity. I asked Matt if he would, kind of take notes on whenever he found a reference to purpose or principles that the original commission was looking at. So who is Dale Parent? Dale Parent was the first executive director of the Minnesota Sentencing Guidelines Commission. So he was kind of an eyewitness to the commission's original deliberations here, and how it came to its decisions on what the sentencing guidelines should look like. So the commission focused on three themes. Maybe this is a little bit before we get into purpose and principles, but I thought they were interesting. The first is that the guidelines should be prescriptive. They should say how sentences ought to be, not how, it shouldn't just merely describe what sentencing practices have been, but really how they ought to be, which interesting note, probably criminal history would have had more of a role rather than less if they had simply described the way sentencing had been in the 1970s. And really the commission thought that offense severity should take take the front seat. And criminal history should sit in the back seat, which we'll talk about in a minute. The second is the commission took that language that the commission should take into substantial consideration the capacity of prisons and jails in the state. And they really made that, they imposed that as a limit upon themselves. So they viewed the existing prison capacity of the state as being a constraint on, because they could figure out, and we still can, use the sentencing guidelines as a tool to help us figure out what the future prison bed impact of a sentencing policy decision will be. And they took that as a constraint on themselves and decided that whatever system they ended up with, it should not require the state to build more prison beds. And then third, they really wanted to get kind of what we're doing as stakeholder engagement. They wanted to get the criminal justice interests and the general public involved. And if at all possible, they wanted to get consensus and general acceptance of the sentencing guidelines when they were promulgated. So this next paragraph is super important. This is the purpose of the sentencing guidelines, prescriptive sentencing policy, emerged as punishment or justice deserts. So if kind of going back to the classical principles of sentencing, which are in section 2B2E, retribution, incapacitation, deterrence, restitution, rehabilitation. And I think there are different ways you can formulate this, but I've seen this list before. But incapacitation, deterrence, restitution, rehabilitation, those are all, I've heard them referred to as utilitarian bases for sentencing. So there's a purpose behind it, right? Restitution, you're trying to, get the victim back with what is owed to them. Incapacitation, you're trying to keep a dangerous person off the streets and keep the public safe. Through that, rehabilitation, you're also trying to keep the public safe, but through a different way of making the offender better so that there's not the same likelihood of reoffending. Deterrence, you're trying to prevent crime from happening in the first place. So these are utilitarian, but retribution doesn't have the same obvious utility. It's just kind of to do the right thing, to make the punishment fit the crime, to have the person be punished. And arguably, there is a utility to that because it engenders general trust in the justice system and lets people let the justice system have this monopoly on force and people don't have to take the law into their own hands. But generally, that punishment is not considered to be a retribution or is not considered to be a utilitarian philosophy. But that is the philosophy that the commission adopted as its primary philosophy. And again, as I said at the outset, this was not something they decided at their first meeting, but it's something that emerged over time as the dominant view. So punishment should be inflicted because the person convicted of the crime deserves the punishment. That's the idea of just deserts. And the severity of the punishment should be scaled according to the harm caused by the crime and the relative culpability of the person who committed the crime. So punishment is an end in itself and not a means to another end, such as crime control. So unfettered by the language about public safety being the primary consideration, the commission viewed punishment as being an end in itself. And I think that was in the original language of the charter statute, that proportionality, the propriety, what is a proper punishment. That's really where the commission took this from. And they also took it from what they considered to be the views of the legislators who enacted the original statute. So rehabilitation, deterrence, and incapacitation were specifically rejected as primary goals in determining the presumptive sentence. And it wasn't rigid. It was sometimes we talk about later using modified just desert. So it wasn't a rigid principle, but it was an anchor. It was a starting point, and it provided coherence of purpose where there otherwise might not have been so much coherence. So here's an application. So these figures show how you might see this in application. And this is a really very simplified view of the grid. And what Parent suggests is that the modified just deserts policy, which arguably is what the commission says they adopted eventually, is shown here in figure 1, where criminal history score has some impact on whether somebody goes to prison or not, especially in the middle severities, you know, where it's not super severe and not super not severe. So for low severity offenses, this figure 1 would say nobody should go to prison. And for high severity offenses, everybody should go to prison. And for middle severity offenses, then maybe it depends on your criminal history score whether you should go to prison. Now, figure 2 looks more like what was actually happening in sentencing in Minnesota in the 1970s, where criminal history score was the primary driving factor, and in determining whether somebody does or does not go to prison. Offensive seriousness really only affected people in those middle criminal history scores. So people with first-time offenders would never go to prison, and career offenders would always go to prison. And it wouldn't necessarily matter quite so much what the offense was. It would be more the criminal history score. And that, in parents' view, is more of a utilitarian model, because you're trying to incapacitate repeat offenders. That might be a simplistic way of describing figure 2, but that's how parent views figure 2 as being more utilitarian. And then figure 3 would be a mixed dispositional policy where it would be equally weighted for severity and criminal history. So that's an application of that. And ultimately, as I said, the commission adopted the modified just desserts approach. And so the design there of the sentencing guidelines was to produce more prison sentences for violent offenders and fewer prison sentences for property offenders. Again, because the focus is on the offense, the crime itself, the harm caused by the crime, and the culpability of the person committing the crime, which, you know, I guess you could argue that culpability is related to criminal history score, but Parent was definitely de-emphasizing that in the book and talking more, I think, about the culpability of the actual crime itself, not so much the history of the person committing it. So after the sentencing guidelines were proposed, the commission kind of went on a public relations tour of the sentencing guidelines and explained to people what the commission was all about, what the sentencing guidelines were all about. This is, I think, after they were proposed, but before they went into effect. And the commission stressed that the guidelines were not intended to achieve deterrence or incapacitation objectives. It stressed that evidence that crime rates can be, and I don't know if there's new research on this, but at least in the early 70s, evidence that crime rates can be lowered by changing sentencing practices was mixed and inconclusive. Our ability to predict future criminality was very weak, and the endeavor was fraught with moral concerns. Should somebody be punished for what they might do, or should somebody be punished for what they did? So that's I think at least one moral concern that the commission might have had in mind. So the purpose of the guidelines was to mete out deserved punishment in an equitable and fair manner, not to reduce crime, which is super interesting now that your charter statute says that the primary consideration is public safety. Does this language, I think this language makes sense. I think it's coherent. I just wonder if it's completely consistent with the way the charter statute now reads. The primary consideration shall be public safety. There was some intended utility. It wasn't entirely free of utility. It was designed to reduce sentencing disparity by promoting similar sentences for similar cases and by assuring that difference in sentences were proportional to relevant difference among cases without reference to race, sex, or economic status of offenders. So I hope that gives you something to chew on, Madam Chair. I know it's a lot, and I acknowledge that I was a philosophy major in college, so this might be more interesting to me than to any of you. But I found this to be a very, very interesting paper to write.
It was a very interesting paper to read too. Comments or questions from the commission? That's a phrase I'm going to pick on you.
This is like a cold call in class.
Totally is. I'm just curious sort of what jumps out to you from this, and I know this is an area that you've studied, so I'm just curious if you have anything you want to add or any thoughts you want to share at this point.
I have written a lot about this. I haven't written anything about it recently, but I don't think my views have changed. I guess I would say, first of all, that the Dale Parent, I mean, he's a fabulous executive director and researcher and reformer. It is, however, an account by somebody who was describing what he did, but also, and as Nate said, looking back, well, what were we really doing? And I guess another way of looking at the history is to look not only at what the commission and its leading spokesperson, Dale Parent, said they were doing, but what they were actually doing. And also what was implicit, I think, in the enabling statute, which was really, I mean, even a strong proponent of just desert sentencing, Andrew von Hirsch, has written that the enabling statute really didn't say much about sentencing purposes. If anything, it embraced them all, which is hard to do. You have to kind of have a structure that harmonizes them some way. And they just kind of threw that to the commission. And the commission was urged by people like Andrew von Hirsch to adopt a pure just desserts model. So he wouldn't want criminal history to play much of any role. He's varied over time with exactly how he would factor that in, but very limited role. And he's a positive retributivist, meaning that people should receive what they deserve proportional to what their blameworthiness, no more and no less. So that means you've got to be just as strict about the upper limits on sentencing severity as you are on the lower limits, and a narrow range between those. And I don't think that's what the commission did. I think what the commission did was to adopt what's called a limiting retributive model that says, first of all, there's at least a wide range of not undeserved punishment. That's Norval Morris's theory. It's also Professor Reitz's model penal code theory. And an alternate version of that is to say it's asymmetric. What's most important is to prevent undeservedly severe punishment. Sometimes there's a lower limit. Obviously, murder, they have to go to prison, just because it's murder. So what they actually did, I mean, the fact that there are no limits on plea bargaining, there are really very few limits on conditions of suspended sentences, which, if fully served, could have no bottom in a sense, supervised probation or less. Again, if they get violated and sent to prison, there's an upper limit on how long they can go to prison, but there's not necessarily a lower limit. So anyway, that's what they actually did, and I think when the legislature said in 1988 or 9 that, well, let's be clear, public safety is the primary goal. It was always implicit, I think, not only in the 78 statute, but in what the commission did, because there is a range, and within that range, public safety, utilitarian purposes are considered, always were, and it's a statement just to remind us, yeah, proportionality is fine, but what the public cares about is public safety. Of course, they do. I don't think the members of the initial commission were doctrinaire about our philosophers. I think they were very practical people. So anyway, we have. I could go on and on, but I think what I take away from all of this is that this commission has a storied history of pioneering sentencing reform work, and our job is to carry that on. I think with consistent with what the commission has actually done over the years and with what practitioners are doing. Because in the end, the sentence depends on the parties who are the prosecution, the defense, and the trial judge and the probation people. And I think what they have done in practice is reasonable. And we should listen to what they do.
Still always blows me away that the original commission created the guidelines on such a tight timeline, you know.
Yeah,
There's a lot of thought in there.
I think they weren't fully operational until late '78. So that meant they had, not much more than a year to actually do something that nobody had ever done before. And including to collect data, which had never existed before. So it would be evidence-based. That's one form of rationality. So yeah, the fact that, Dale Parent, Jan Smavy, the chair, the terrific members, judges, especially Doug Amdahl, it was an amazing accomplishment. And I'm cheering for the home team here, but I think it's something that the state of Minnesota is justly proud of.
I would agree. Other thoughts, reactions? All right, I'll react then. I think another, a couple of things that always bear thinking about. I think it's really interesting that the original commission decided to take a prescriptive approach with sentencing rather than a descriptive approach. They definitely did collect data and they looked at how sentencing was occurring in the field, but then they also took a second look at that data to say, well, is that how sentencing should occur in the field? Or should we do something with the structure that we create so that it looks a little bit different than that? And that is really, the structure that we have today still carries that forward, right? There's always the structure that we've built sets the benchmark, like for what sentencing should be, but we leave that room for a few decisions to be made that maybe it doesn't work in every case, right? Maybe there's some room for individual movement. But at the same time, I hope as a commission we recognize that when we're seeing a lot of departures in a similar area that are happening all the time, there's also a signal back to us, right? That there's something off about the way that case might be, those particular types of cases might be working. So that's that high departure rate offense category that the U is going to look at for us. So I think it's really, there's this constant tension between sort of what should the policy be, how does it actually play out in the field, and how much do we want to take that feedback in, and what should we do with that information? So I think that's sort of history cycling through again. And then the other piece that I always find really interesting to think about, again, is the capacity constraint. The fact that we actually do look at what the capacity is of our correctional system, and we try to work within that capacity, not in a way that's going to explode it. There are states that never collect data and never really evaluate. If we pass this law, what is that going to mean for our prison capacity? Are we going to exceed it? Are we going to stay within it? Are we going to need to open a new facility just for this one new offense? There are states that never think about that, never do that. Our state does that. We collect the data, we review it. Every single new crime legislation gets a fiscal note, and the legislature has to grapple with whether this is one where they want to put that investment in to increase the capacity so that we criminalize this offense. DWI, felony DWI being one of those. I'm sure the fiscal note on that one was high, but it passed because that was something the legislature, that's where they wanted to invest, but there's other offenses that have not passed because of the opposite consideration, right? It's too much of an impact. So I think it's really important to think about that capacity constraint, what our responsibility is for, you know, deciding in which situations prison is the appropriate sanction, right, as a general rule, not taking departures into account. So those are just some of the things that sort of jumped out at me, and every time we look at those, look at the original principles, those are the things that kind of jump out at me as some of the more interesting points. Anyone else? Have anything else to, Commissioner Knudsen?
What you just said was stunning. I mean, how can, having only operated in Minnesota,
Uh-huh.
that's all I know. How can you run a Department of Corrections or a judicial system without looking at and anticipating and planning? And other states aren't doing it, gathering that data. That's amazing.
Sometimes states come here and get amazed by what we do.
In a positive way, I hope.
In a positive way. In a positive way. Yeah.
I think of California, Madam Chair, where their biggest criminal justice reform was in recent years was caused by a lawsuit, you know, in connection with overcrowding in the prison. So it wasn't an intentional thing. It was kind of done backwards.
Yeah. Any other comments? Questions? All right. Well, thank you, Nate, for giving us that first little bit to chew on. I'm hoping that Professor Rice will be willing to come back and give us the broader overview of what other states sort of put in their principles section, you know, those ideas. You started it at a prior meeting, but maybe we could have a more focused conversation on that in a future meeting. He's nodding, maybe. All right, next item on the agenda then, we'll move on to Minnesota's prison population. We have Dr. Grant Dewey here from the Department of Corrections to give us a little presentation. Come on up.
Grant, do you want to sit here?
Or, oh, yeah.
The camera would catch you.
Wherever you want me to be.
I think this would be easiest on staff, so that'd be great. So, and this is Dr. Grant Dewey, the Research Director for the Minnesota Department of Corrections. He's here to discuss some questions that the commission raised. Was it last meeting or meeting before about?
I guess last.
Last meeting, I think the vice chair might have primarily brought this up. So, just talking about who's in prison, basically, is my understanding.
So yeah, with those instructions, I was also told, and by the way, you have about 15 or 20 minutes. So this is about a mile wide and an inch deep. So, but I thought it was a good idea to at least kind of give everyone sort of a historical perspective on where we've been and how that informs where we are today. So when we look at this graph right here, so this shows what Minnesota's prison population has been since 2000. So I'm going to go ahead and stand up here for just a second. But so in 2000, and unfortunately you can't see this at the bottom here, but our prison population was a little below 6,000. There we go. And then, so you can see though that in the first, I would say that like the first decade of this century, we had astronomical growth. We went from 6,000 to a little more than 9,000 by the end of the aughts. And then we plateaued around 2015. You see that we went up to a little more than 10,000. And then even though our prison population dropped precipitously due to COVID, our reduction had started before COVID. So in around 2017, we dropped from a little under 10,000 to about 9,100, which is where we were before COVID. And that was largely in response to some changes that we made when it comes to supervision. People after they get released from prison, but then as you'll see later on, even like when we look at probation violation admissions to prison, that had started to drop too. And then after COVID, you see that we start to rebound a little bit, but we haven't quite bounced back to where we were before COVID. But what is interesting though, is on January 1st of this year, our prison population was 8,275. That's almost the same number that it was back in 2004, which was 8,333. So I'm going to offer that as kind of our point of comparison here. So next slide. All right, so in 2004, just when we look at gender and race, this is one thing that has almost always been true. About 94% of our prison population are men, 5 to 6% are women. When we look at our racial and ethnic makeup of our prison population, in 2004, 58% of people in prison identified as white, compared to 50% earlier this year. Now, part of the reason why that was the case is in the early 2000s, some people may remember this, but that was the time of the meth boom. Like a large reason for our prison population increase, especially from like 2000 to about 2005, was due basically to two things. One was meth, the other was the creation of the felony DWI law in 2002. So that actually increased the percentage or people coming into prison for meth offenses were at that time not disproportionately, but were more likely to be white than for other offenses. And so we actually did see an increase, but then it's come back down to 50%. People identifying as Black, 33% in 2004, 38% in 2024. And then the other racial and ethnic categories, basically the same. So when we look at types of offenses, why people are in prison, in 2004, about half the people in prison were in for a violent offense, like sex offense, assault, homicide. 25% in prison for a drug offense. Again, meth, big driver for that. Property, 12%. DWI, 7%. Weapon offenses, 4%. And then other, which makes up a whole list of offenses, 10%. So fast forward to January of this year, person offenses make up 57%. That's down a little bit from a couple of years ago, which I think is about 58 to 59%. One of the big changes is drug offenses, 25% in 2004, 16%. Property offenses was 12% in 2004, 7% in 2024. Weapons offenses, I believe it was 4% in the previous slide, 10%. We have seen an increase in people in prison for weapons offenses. DWI was the same at 7%, and others also 10%. So back in, I think it was about 2015, 2016, we presented to the legislature, talked to them about how we were running out of space. Like, as you recall from the first slide I showed you, our prison population was about a little over 10,000. We went to the legislature and said, look, we don't have any more prison beds. That was a couple years after we had used Prairie Correctional Facility for at least up until I think it was like 2010. But we were using jail beds to house the overflow. And so one of the questions the legislature had at that time is, well, why has our prison population increased so much? And so a large part of our response was, because you increased the penalties. That's why. And so part of our explanation here was, looking from 2000 to 2015, seeing our population increase by almost 4,000 and looking at some of the reasons for that. So like when we look at person offenses, from 2000 to 2015, we increased by about 1,500. But then over the last 8 to 9 years, we've seen a decrease of about 500. As you can see, people in prison for sex offenses, that number has been basically the same over the last 9 years. We have seen an increasing number of people in prison for homicides. One of the big changes that we have seen, and this is in response to statutory changes that were made around like violations of orders for protection, DANCOs, and so on. We do see a pretty big increase for people in prison for domestic assault, violations of orders for protection, and so on. Drug offenses in 2000, we were a little more than 1,000 people in prison. That jumped up to, or that almost doubled to 2015. But then, you know, as I showed in a previous slide, we're now back to like 1,300. Meth offenses, we used to track that much more closely, but not as much anymore. Property offenses, as I alluded to, our numbers are much less than they were back in 2015. And then a couple other offense types that are worth highlighting, like I mentioned, weapons offenses. You know, over the last 24 years, we were at 189, and now we're at 822. Felony DWI, you know, back in 2004, that slide that I showed you, we were about like, you know, 350, 400, and then we increased, but over the last 9 years, we've dropped by almost 300. And then failure to register as a predatory offender, those numbers have also dropped. So, you know, some of the reasons for those increases that we do see, you know, like weapons offenses, we see, you know, mandatory minimum increase from 1.5 to 5 years in the late 90s. Failure to register as a predatory offender, you know, prior to 2000, that was not a felony level offense. So people who failed to register, they didn't necessarily go to prison for that. Felony DWI, as I mentioned, that was enacted in 2002, and then, you know, we see a whole slew of penalties increase for domestic violence in the mid-2000s. One of the other notable things that we have seen with our prison population is that it's getting older. In 2004, the average age or people in prison was 34. So earlier this year was 40. So that's one of those things where it doesn't really jump out to you until you look at it over time. And so like 6 years difference in average age, that's a pretty big increase over a 20-year period. So like people in prison 50 years and older, in 2004, 622 individuals, which was 7% of our population. It's almost tripled in size earlier this year to 1,857, or 22% of our total. And then when we look at people in prison under the age of 18, we had 22 in 2004 compared to 4 earlier this year. One of the reasons for the aging prison population is we do have more lifers in prison. In 2004, we had 364, which is 4% of our prison population, compared to earlier this year, 523 Minnesota lifers in prison, 6% of our population. Of those, 167 life without parole. And when was life without parole enacted here?
Well, it was, I mean, the big change was when it was enacted for first-degree premeditated murder, because it was very selective, I think, as early as the late 90s, but I want to say in the mid-2000s, it was expanded to first-degree premeditated murder, which is by far and away the most common category of first-degree murder. So the exception kind of swallowed the rule at that point.
Okay. So I know in our reporting, we really didn't start tracking that until about 2012. So I was thinking it was probably the mid-2000s that change was made. So we had 101 people with a life without parole sentence in 2012, whereas earlier this year was 167. So that's kind of the part of the presentation that looks at the stock part. Now we're looking at the flow, or the admissions into prison. So one of the things that you can see here is, well, so there are three main types of admissions to prison. So There's a new court commitment where someone commits an offense, they get convicted, they get sentenced directly from court to prison. Then there are people who come to prison as probation violators. You know, they get sentenced to probation, violate the conditions, revoked, get admitted to prison. And then we have supervised release violators, people who have come to prison either as a new court commitment or as a probation violator. They spend time in prison, they get placed on supervised release, they get revoked and then return to prison. So when we look at new court commitment admissions, in 2015, again, this was sort of at the height of our prison population, we had almost 3,200 new court commitment admissions, and you see up until 2019, it was pretty close to 3,000. But then in fiscal year 2020, that's affected by the onset of the pandemic. So we see our numbers drop to 2,300. And then in fiscal year 21, where we were definitely in the throes of the pandemic, it was 1,700. But then once vaccinations became available, things started to open back up a little bit. We see the new court commitment admissions jumped back up to 2,600. And then our most recent fiscal year was 2,700. So we haven't quite snapped it back to where we were. And this is, so CINSE Guidelines, Department of Corrections, we collaborate to forecast our prison population. So my last slide, I'll kind of show you what we anticipate is going to happen over the next 5 years. But one of the topics of discussion that we would have during our meetings in forecasting the prison population, especially during COVID, is like, are we going to bounce back to where we were? And if we're not, what is this new future going to look like? And so, so this is, so far, this is kind of our new reality where we haven't snapped back to where we were before COVID. We're a little below that.
Is it going to be a V or a check mark? You know, kind
Yes.
of, what's that going to look like?
So when we look at probation violator admissions, one of the things I mentioned at the beginning is we started to see a drop in the size of our prison population before COVID. We went from a little under 10,000 to about 9,200 at the onset of the pandemic. And a big reason for that decrease has to do with the numbers that you see here, where prior to 2018, we were seeing around 2,000 probation violator admissions to prison each year. And I would say that was relatively stable over time. But then in 2018 and 2019, even before the onset of the pandemic, we see fairly big decreases. In fact, it's like about a 25% decrease from 2019 to 2017. But then, you know, this is one area where even after the pandemic, we're still at relatively low levels for probation violator admissions. Same is largely true for supervised release violator admissions. Our zenith was in 2017 where we're a little over 2,800. But then we do start to see a decrease even before COVID. And I know that, you know, some of the changes that we made to our policies and practices around, you know, people on supervised release, what we do with folks when they violate conditions, making it more difficult for people to get revoked. Just because our impression at the time was that it was far too easy for agents to revoke people and place them in prison. And one of the things that our research was telling us is when people were getting revoked, either for a probation violation, supervised release violation, come back to prison for short stays. And what were they doing while they were in prison for those short stays? Nothing. And so essentially people were coming back to prison. Sometimes people will talk about therapeutic communities, right? Well, you know, this was sort of like a criminogenic community where we're basically housing a bunch of people together who had violated their conditions of supervision in the community, placing them in a correctional facility and not providing them with anything to do. And so not surprisingly, we were seeing significantly worse recidivism outcomes for those folks. And so one of the strategies that we did try to implement is making it more difficult for people to get revoked and come back to prison. So that partially accounts for some of the drop that we've seen in our supervised release violator admissions, and those numbers have stayed relatively low since the onset of the pandemic.
Madam Chair?
Yeah.
Can I just point out something? So Grant, it's true that this third category, release violations, is unique in that it's in the control of the Department of Corrections, whereas the other two, the probation violations and initial commitments, are in control of the court system.
That is a very important distinction. Yes. Yep. And so for these last couple slides, I'll just break it down by admission by offense type for gender admissions that we've seen over the last 5 fiscal years. So for the women, initially direct your attention to the far right column where it says total. So for all admissions to prison for the women, it's 17%. For criminal sexual conduct, it's 1%. So just for person offenses or violent offenses for the women, it's only 18% of admissions. Drugs account for almost half of all admissions to prison for women. Property offenses, 22%. So property and drug offenses for our female population, those are about 70% of all admissions. DWI 6%, weapons is a little less than 1%, other offenses 6%. One of the other things that's notable about our female population, at least when we look at admissions to prison, is almost half are for probation violations. So you see that 46%, so that's almost half. That's not some recent characteristic, that has long been the case. Where for the women, almost half of the admissions to prison are for violating conditions of probation. And as you can see, drug offenses, when women who get placed on probation for drug offenses, they get violated, come back to prison. That accounts for 55% of those. And then for new commits to prison, those make up about 1/3 of female admissions to prison, whereas release violators for the women, it's about a little more than 20%. And then for the men, new commits make up half of our prison admissions. So that's one. So yeah, I was thinking I might present some information on like how lengths of stay vary by admission type, but then I remembered how much time I was given, so I didn't do that. But there are big differences in like length of stay by type of admission to prison. So like new court commitment, length of stay is quite a bit longer than it is for a probation violator, and then shortest lengths of stay are for release violators. So for the men, probation violator admissions 18%, and then release violators make up about 1/3. So when we look at admissions to prison, non-sexual violence and criminal sexual conduct, those are violent offenses, 42% of admissions to prison. Now, like if you think back to like one of the earlier slides that said, well, 57% of the people who are in prison are there for a violent offense, including sex offense. That, 57 versus 42%, well, the people who come to prison for non-sexual violent offense or criminal sexual conduct, they have longer lengths of stay. And so that's why even you see smaller admission percentages, the people who are in prison for those types of offenses make up a larger percentage because of that. Drug offenses for the men, not quite as of a high percentage as for the women, 22%. The other thing worth noting is weapons, it's like 1% for the women, 4% for the men. So, and then I just wanted to point out real quick. So this slide that I presented at the beginning, like if you look at like the last couple of years, we bounced back. I would say like we were almost down to about 7,000 for our prison population. But then we saw an increase of about 1,000 within a short period of time. And so as I referenced earlier, the Sentencing Guidelines Commission were like, wow, that's a pretty big increase within a short period of time. Are we going to continue this trajectory? Because if that's the case, then as I'll show in this next slide, then we're in a lot of trouble because of our operational bed space capacity, which currently is 8,885, which is, one of the things that happened during COVID is COVID made operating a correctional system a lot more expensive in terms of like having to do social distancing and all the health and safety protocols. So our operational capacity is actually a little lower, but we went from about 7,000 to about 8,000 within a very short period of time. And so, one of the things that we had to look at is like whether we're going to be at a point where we're going to be exceeding our operational capacity. But fortunately, over the last couple of years, we seem to have leveled out a little bit. And so because of that, our most recent projections suggest that we should see some increase in our prison population over the next 5 years, but not a huge one. So that's all I have. So if anyone has any questions, I'd be happy to address.
Commissioner Fraze and then Commissioner Ladd.
Am I correct in assuming when you were talking about the decline, I think you said since 2017, in admissions for probation violations and for supervised release violations, those are admissions to DOC prison, so that if somebody was violated but just sent to jail, they wouldn't count in that?
Well, if they violate and they get revoked, then by and large, they've been coming into one of the state correctional facilities.
Okay. If there was an alleged violation, and I guess they go and pick them up and they put them in jail initially.
That would not count as part of these numbers. Or if someone violates, they're held in jail, they get restructured, that would not count as a prison readmission.
Does your department have data these days on state jail populations?
We include that as part of within our performance report. I don't have it off the top of my head though.
Commissioner Ladd and then Commissioner Reeves.
Thank you. I have two questions or comments that is going to piggyback on what Commissioner Fraze just talked about on the length of stay. I know you said you didn't have any slides on that, it's a whole other thing. But I think that's interesting. I think that's an interesting data point for us because I think when we talk about prison population, I think you said in quotes, we actually have a lot of prison populations being served locally in our jails and so on. People actually get committed to the Department of Corrections to serve the sentence. The length of that sentence may not be the pronounced sentence at the time they were sentenced. And so I would like to see something about that. And along those lines, I'm also curious, because I never see data about it, as to how often, or if there's a percentage of how often good time gets revoked on sentences for persons who are at the Commissioner of Corrections. So if someone gets sent to prison for 60 months and they serve 40 because they get 20 months of good time, like how often does the full sentence on that 60-month sentence actually gets executed as opposed to never? I'm guessing there's probably some, but in terms of that good time being revoked and being imposed, because again, that goes back to my first point about the length of someone's stay and what factors play into that.
Is the question you're asking, is it like someone who has that 60-month sentence, how many serve all 60 months in prison? Is that what you're asking?
Yes.
Okay. Not many. It's a pretty low number. The department there are several main types of penalties for discipline infractions. I mean, basically the only way that a person is going to lose that 1/3 of community supervision time, what you were calling good time.
Yeah.
That it is through misconducts in the institution. There are some people who rack up, or the main types of sanctions for that, it's extended incarceration, as well as segregation. But I will say that as an agency, we have been, or at least are moving towards a place where we'll be imposing extended incarceration time less. Because like when you think about like the principles of deterrence and, you know, a penalty that's swift, severe, and certain, like that's what's going to deter somebody. But, you know, someone who's in prison who commits an infraction and they're not getting penalized until like a couple years down the road, like, you know, someone who's in prison, it's like they get they get a discipline conviction and they get 15 days of EI, but it's not going to count until like, you know, 2 or 3 years later. So that's not exactly the celerity part of deterrence. So as an agency, I anticipate we'll be using that less and less. And so what that also means is that you know, it would be very difficult for someone to serve all 100% of their time, of their sentence in prison.
Commissioner Reeves.
Thank you, Madam Chair. This is interesting information, especially when we think about what probation in particular has been doing to reduce executions going back into prison, just really doing all it can in community. It's kind of nice to see it reflected in those numbers. Commissioner Ladd asked my question, but I was making a comment about, dang it, I lost my train of thought. I knew I was gonna have it, I should wrote it down. I'll come back, John. I lost my train of thought. I was gonna ask off of your question, so I'll come back. Thank you.
You think of it, just raise your hand.
Yes.
Was there someone else who had a hand up? No? Well, you better think of it now then. Oh, Commissioner Middlebrook has a question. Good.
Thank you, Madam Chair. My question is, it's very interesting with the numbers for the women population. Particularly, I'm wondering if you have the breakdown on different races, because we did get something from about Native American women being, their probation being revoked like immediately, or like the first time they are back in court. And that was raised to us, I'm not sure if it was, is it in the last couple of years? I was just curious if you've got that data as well.
I didn't have it here, but I do, like the last time I looked, I think 20% of our population at Shakopee are people who identify as Native American, which I mean is an astronomical percentage when we consider that people who identify as Native American make up 1% of our state's population.
And then do you also have that for, as far as what the offenses are? Are they drug offenses or are they property offenses, since that's such a high category there?
Well, it's still, I mean, for all of the women, Native American women included, we still see more drug and property offenses, especially in comparison to the men. But the last time I looked at it, I do recall that for the women, at least Native American women compared to everyone else, we do see a higher percentage in for a violent offense.
I remember my comment. And so a lot of times when we're doing, bringing people, when they're issuing a violation and are executing a sentence, we're potentially sending them to the adult correctional facility as opposed to sending them to prison. Do you guys keep track of that information as well, or just strictly going into prison? Because we have people that will execute, and then depending on what time they have, they send them to the courthouse and don't send them to prison, but they've executed their sentence on a felony. I'm just curious.
Yeah, and that does happen occasionally, not that frequently, but those, because that is considered a revocation, that would be included within our numbers.
Any other questions?
This issue comes up time and time again about the jail populations. And the same kind of data or statistics or information on that population over time, for what offenses, that kind of thing. Does anyone look at that? Does DOC look at that? Local incarceration?
Well, I mean, each county might be able to tell you that, but not the DOC.
87 of those.
I know,
So-
I know. But not the Department of Corrections. I mean, we have an inspection and enforcement unit where there are, they oversee that, but in terms of what you're asking, no.
How can we get that?
It's a really good question.
With a lot of effort, I imagine.
With what?
With a lot of effort, I imagine.
Yeah. All right, any other questions or comments? All right, well, thank you, Grant, for coming. This is a really great presentation and really, really interesting information. So I really appreciate you joining us today. All right. Do you have something?
No.
We're up to sentencing guidelines in operation.
Yes, and I'm smiling because at our preparatory meeting, we said if we didn't get to this by 2:45, we'd pass, and it's now 2:47. So I'm gonna say,
I
why
think
don't
we
you
made
come on
it.
up? Why don't you come on up? I'll try to be very, very, very fast on my executive director's
I think we made it, yeah.
Okay.
So close. Go ahead, Leah. Am I starting? You bet. Okay. All right. So we have a little bit of time. We are going to do another case study. If you remember last time, we did a case study on John Doe. And that was a case of a charge with a felony possession and a misdemeanor assault, misdemeanor theft. So we're going to do a little bit different case today. It's a little more complicated, not super complicated. And so I will read again the narrative, and then Linda will talk about how the worksheet was completed. All right.
Jane Rowe.
So this is Richard Rowe, maybe a first cousin, or I don't know, but that's what we're going with. And this case is a Hennepin County case. It's Richard is he's a white male who was 38 years old at the time of offense. So here's what happened. On May 6, 2022, at approximately 7:48 a.m., police were dispatched to an address on 36th Avenue North in Hennepin County in regards to an unwanted person. Call note states that the reporting party's ex-boyfriend is harassing her and that she has a domestic abuse no contact order or a DANCO in place. Her ex-boyfriend was said to be Richard Rowe. Richard took her keys and went into her apartment. The reporting party, Jane, then told police she was mistaken and that she only thought she saw someone that looked like her ex. As police spoke with her, they observed that she appeared to be upset. Her face and makeup appeared to be in disarray. She was not wearing any shoes outside, and the tone of her voice sounded panicked. Police researched the active DANCO in place, prohibiting Richard from being at the address from having any contact with Jane. Richard was listed as the respondent on the order, and the reporting party was listed as the protected party. The order was issued on August of 21 and is valid through August of 24. And the order was listed as being served to Richard during court proceedings. 30 minutes later, at 8:20 a.m. the same morning, police were dispatched to a call on 31st Avenue North, which dispatch believed was related to the prior unwanted call for service. So police went to this address and made contact with a male called Tim, who stated that he located a backpack with belongings, as well as a jacket on a picnic table near the outdoor break area. Police located a wallet in the side pocket of the backpack and looked inside it to attempt to find an owner for the property. Inside was a paper DVS photo identification belonging to Richard and an EBT card belonging to Richard, as well as another card with Jane's name on it. Police then returned to Jane's apartment and could hear a male voice inside. They spoke to Jane, who eventually let them in. Richard was found hiding in a closet inside Jane's apartment. Richard was interviewed and stated he was aware of the court order which prohibited him from going to this address. Richard was then charged on May 9th, 2022 with a felony violate no contact order within 10 years of the first or two or more convictions. Richard was assigned a public defender, and on November 30th, he pled guilty to this count. On December 20th, he was sentenced. The judge pronounced a 30-month prison sentence and stated to put Richard on probation for 3 years. Richard was ordered to serve 60 days of local incarceration or local confinement in Hennepin County in the Hennepin County Workhouse. All fines and fees were waived. This was not a guideline sentence, as the judge departed from the guidelines recommended sentence. On the departure report, it was the reason cited for the departure was Richard was particularly amenable to probation and shows remorse, accepts responsibility. The departure report also indicated that there was a plea negotiation on the sentence. Richard remains on probation. So that is the narrative, and now I will hand it over to Linda to talk about the worksheet.
Hi, everybody. So the narrative behind this worksheet is that it was created for a violate no contact order within 10 years of the first of 2 or more previous convictions. This offense is ranked at a severity level 4 from the standard grid, and the worksheet includes 8 prior offenses in criminal history, plus a custody point. The offense that Richard is charged with is an enhanced offense, meaning it is a misdemeanor offense that is able to be charged as a felony due to the existence of specific prior offenses found in Minnesota Statute 609.02, subdivision 16, known as the Qualified Domestic Violence Related Offenses Statute. Because it is up to the charging authority to determine what offenses are used to enhance, the commission's role with these enhanced offenses has been to establish a policy covering the use of the offenses that were used to enhance this offense to the felony level. Because the statute defining qualifying priors includes all level of offenses, from misdemeanor to felony, the commission policy for this is to assign a custody point value for any prior used to enhance, to include all felonies used to enhance in criminal history, but to remove all misdemeanor and gross misdemeanor level offenses that were used to enhance the current domestic related offense. For this offense, the charging authority used a gross misdemeanor domestic abuse no contact order and a felony level threats of violence. This means that the felony will remain in criminal history, the gross misdemeanor will not be included, and the custody point can be assigned. As you can see on Richard's worksheet, with the rounding of the felony points to 5 and the full custody status point for the threats of violence, which is a severity level 4 offense and was used to enhance, Richard's total criminal history points are 6. Under the guidelines, a severity level 4 with criminal history points totaling 6 carries a disposition of prison for 30 months. This sentence also includes a range of 15% below and 20% above the duration on the grid, calculating a prison sentence without departure within a range of 26 to 36 months. As Leah stated, when he was sentenced to 30 months, but was placed on probation, which triggered a departure, reasons which Leah gave, particularly amenable to probation, shows remorse, accepts responsibility, and that it was also based on a plea agreement.
That's the end of the explanation. All right, questions?
I'm sorry, that's the end. Click.
What's Richard doing now?
Yeah.
Richard is still on probation. At this last check of the record, he remains on probation.
Commissioner Larkin.
I'm curious that one of the reasons is it was based on a plea agreement. I mean, we have case law that says a plea agreement is not a substantial and compelling circumstance justifying a departure. So is that literally a reason that's being put in a report and submitted to the court, or? No, okay, that's.
It's just the bottom of the departure report is how did this come about?
Oh, I see what you're saying. So it's not offered as justification.
Right.
Yeah, technically, the way we have it designed is there's section 1, frequently cited reasons for departure,
Understood.
and section 2, additional information. So
Okay.
technically, not a reason for departure, but maybe it is.
No disagreement. I'm just seeing how this plays out.
A lot of things become.
Other questions or comments?
He started crying. Oh, okay.
So I just want to be clear, because even I don't know the policies backwards and forwards. So the offense is one that is enhanced to a felony because of prior related offenses. So for any of the priors that were used to do that were not felonies, we don't count those in criminal history. So our guidelines are sort of treating that like it would be like double counting. But if a felony is used to enhance, we do count that.
Correct, yes.
Commissioner Middlebrook?
Yeah, this is one area I will say that is extremely confusing and start, questioning what's used for the enhancement, why is it double counted, et cetera. Another question I guess I have for Linda is on the listed offenses, there's 4 of them that are all disposition date's the same date. So because they're obviously all sentenced the same day, is there any look at what those are, if it's all part of a single behavioral incident, or if it should have only been counted for 2? I don't know how much look there is at those. I mean, that's what we look at when we're reviewing these to see if there's any issues.
Are you speaking to all, Madam Chair, Commissioner Middlebrook, are you speaking to the ones from September of 2022?
Yes.
Now going into great detail, I will tell you that all of those would have received an imposed sentence. And because they do not meet the exceptions that we have for the Hernandizing rule, which carries over into counting criminal history, those would all be eligible to be included because they all were sentenced prior to sentencing on the current offense to a felony level sentence or a stay of imposition.
Is that the same date as this sentencing, or is it a prior event?
Prior. It looks
I
like
believe this was sentenced in December, and these were September offenses. But this one occurred before those were sentenced, but those were sentenced before this one was.
So he committed the current offense. So he committed the current offense, then he was sentenced for these, and then he was sentenced for the current offense.
And he pled guilty before as well, so after he was sentenced.
And if I could just make a comment too, we talked about double counting. In this case, it's triple counting because not only was it used to enhance the misdemeanor or gross misdemeanor to a felony, but it was also included in the criminal history score for a point. So it moved one square to the, and I'm talking particularly about this threats of violence case, right? So it was used in the criminal history score for a point. It was used to enhance it to a felony, and finally it was used for custody status because he was on probation for that felony. So So he got on the grid, on the felony grid because of that, plus he moved over a square because of that, plus he moved over another square because of that.
A lot. I truly thought that our rules were written so that we didn't count in criminal history anything that had enhanced, but maybe that's just in DWI.
Well, it's true for misdemeanors, right? Right, Linda? Honestly, I don't say anything about the guidelines without asking all this.
When an offense is enhanced, the misdemeanors and gross misdemeanors used to enhance it are left off for the first offense that they are enhancing. What you're speaking to is the policy that relates specifically to DWI offenses. I don't want to speak with authority of what the commission was considering at the time. However, I can say that domestic related offenses are enhanced every time. There is no felony provision that says you automatically have a felony after you have your first felony. Unlike DWI. DWI is an automatic felony and therefore not considered an enhanced offense for a subsequent. However, the commission felt that potentially, I hope I'm saying this correctly, because of that, those first 3 misdemeanor, gross misdemeanor DWIs used to enhance the first offense would not be repeated in future felony DWI criminal history.
Thank you. That actually rings some bells for me, so I appreciate that. Commissioner Larkin.
I'm not sure if this is a question or observation. So is this an actual?
Yes, this is, everything is the same except the date of birth has been altered to a fictitious, impossible date and the name has been changed.
So one thing I don't understand is the last 4, which shows, well, all one date of offense, September 20th, 27, right? Or no?
That's the expiration date.
Expiration. This is the dispo. So we don't know what the offense dates are for these.
Right.
Right, okay, so we're not assuming they're all one.
And we couldn't have had 6 and 7.
Right.
Occur on the same day, to Cashman's point. I mean,
Yeah, because I mean, 609-035, you can't have multiple sentences for one course of conduct. So I just wanted to make sure
Been a different victim though.
that,
Different victim, yeah.
yeah, clear that these are all different dates.
I think that's what Commissioner Middlebrook was actually questioning, is like, to what extent do we look at whether or not these were a single behavioral incident or not?
Just had 4 outstanding cases.
Okay, so for this person, presumably these were all different dates. They were all just rounded up and handled at one time, at one court hearing.
tagging along.
Tagging
I don't
along.
know. I'm sorry, I didn't know if that question was for me. My apologies. Chair Mitchell, Vice Chair Larkin, we don't know what the offense date is on those. What we have to rely on is that the probation agent knew, and if there are any issues with that would be raised in court by the defense. What we're looking for is whether or not this meets any of the exceptions that we have in place to counting these multiple types of offenses under, as you stated, 609-035, and the exceptions that we have in the guidelines related to how single versus separate course of conduct offenses are sentenced. But those lean much more heavily, as the enhancement of the offense does, on the legal side of things. So coming in from the guidelines perspective and applying the policies, we're looking for, was there an imposed sentence or stay of imposition before the current offense? And does it meet any of the exceptions for inclusion? Exceptions being related to a burglary, a kidnapping, or methamphetamines involving a child or a vulnerable adult, or a single course of conduct, multiple victims, which I'm happy to get into if you want, but I don't know that you want to do that right now. But nothing about these raised any sort of warning flag for us. And so therefore they were able to be counted as the policies indicate.
Commissioner Larkin.
But, and I agree, my concern is I don't want the impression to be, oh, well, look, we've double, triple counted. We've, taken somebody who did one thing and we're racking them up with all these points. It's like, this is, if the law is applied correctly, a situation where there were multiple offense dates or an exception, which would allow for multiple sentencing. I guess I don't understand why we wouldn't have the offense date on the sentencing workshop. I mean, as a judge, that's something I would like to know, and I'm surprised it's not here.
Any response to that before Middlebrook?
Yeah, I'll respond to it.
Oh, you are, okay, Commissioner Middlebrook.
Thank you, Madam Chair. Just to respond to that, because I see these all the time, we see these and we're looking at them to determine whether or not these were, if they should have been sentenced or included separately. Usually the pre-sentence investigation will list those. And that's what we go to the next, we go to that next, look and see what the offense date is. And if it's the same date and it's just multiple counts, then go the next step. So but that information is usually in the pre-sentence investigation report.
Commissioner Ladd.
Just piggyback on that, it is in the pre-sentence investigation, and where I practice, this is the cover sheet, and stapled to this has the cases, and it's got the court file number on it, and it's got the offense date, and this is like first sheet, and I don't know if that's something that's being locally created with my community corrections group, or if that's something that the guidelines thing generates, but that's a helpful thing. So we do get to see sort of that all enumerated in addition, and I think probably what happens is they're taking it from the PSI and just, I'm gonna say cut and paste, because I'm sure there's some more work into it than that, but it's kind of repetitive data that way. So we actually kind of see that, and so does our judge, because that's what gets filed with the court.
Yeah.
The CRS.
All right, other questions or comments?
She's talking about the patient. We stopped doing the patient years ago. We used to do the patient. We don't do that anymore.
All right. I think we've done, thank you so much. That was really interesting and informative. So thanks to both Leah and Linda for that.
Thank you for asking us.
And to circle back to how we began this last month, these are just intended to be example cases. They're not intended to get at a particular issue, although obviously particular issues came up. And we anticipated that. But I mean, if you would like us to, do a case that explores the nuances of Hernandezing or criminal history, or double counting or whatever it is, we'd be happy to do that during the course of the comprehensive review.
Yeah, so if there is any particular issue that you're interested in seeing how it plays out, please do let us know. And staff can work on giving an example together for us. Commissioner Larkin.
And I honestly don't know the answer to this. So generally, the rule is if a prior offense was used to enhance the offense to be sentenced to a felony, that prior offense is not counted in the criminal history score.
It's not counted in the misdemeanor, gross misdemeanor section, but
it is for the
but it
felony.
would be in the felony section. So, right, Linda? All right.
Yes, it is counted in the felony section. Misdemeanors and gross misdemeanors are removed, but any offense used to enhance can be used as a custody status point, even if it's left off of its corresponding criminal history section. So they would get a half a point for the misdemeanor custody, but not the units within the misdemeanor, gross misdemeanor section for those priors. Felonies, however, remain regardless.
Yeah, can I actually ask a follow-up question? Because I think you did cover this and now I'm questioning what I heard. Let's say, so the person had an offense that was enhanced, and so the first time around, we did just what you said, maybe it was enhanced because of a misdemeanor, gross misdemeanor, we didn't count that. Now they've committed another offense. Do we go back now and count those misdemeanor and gross misdemeanors that were used to enhance the first repeat of that behavior?
Yeah, thank you, Madam Chair. Those would be used to enhance, those would be used as criminal history if they were not used to enhance. And
Okay.
because of the depth of that qualified domestic violence related statute, the depth of choices from misdemeanor to felony, there is no automatic felony for a domestic offense. So we're only going to leave off of that new domestic what was used to enhance that offense.
Got it.
However, the felony that they previously had goes on, as well as any misdemeanor or gross misdemeanor offenses that enhanced the first one if they were not used again to enhance the new one. It's DWIs that are removed permanently from any future DWIs.
Got it. We just had to overcomplicate it.
I was gonna say, could that be any more complicated? And that's what we hear across the board. Why are the guidelines so complicated? That they couldn't be more complicated.
And Linda, it's the prosecutor's choice too, right? So if the prosecutor says, I'm using these two felonies to enhance, we're like, okay. We don't second guess that and say, well, why don't you use these two misdemeanors? And then they wouldn't be.
Correct. Correct. Director Wrights, our role is to ensure the correct usage of those priors that were used to enhance.
Wow. Okay. If anyone has a light bulb moment about how to simplify that process, maybe we can take that up. All right. Thank you so much. Okay, I think that we are on to Director Wright's executive report.
Thank you, Madam Chair, and I shortened it up somewhat by already introducing our new staff members, and we are still expecting one more from Alaska. He's taken a little while to get here, so it's understandable. But we're pretty excited about our new staffing situation. Wanted to talk a little bit about the legislature. They're going hot and heavy. We are just like earlier this week, kind of cooling down a little bit on fiscal notes, and I think that's because the deadlines are really coming up. I did share with you a bill that they're kind of two doozy bills that came from, I'll call them that came with respect to adding to the work of the agency, specifically adding to the work of the agency. One had to do with really compiling a whole lot of data, and I will say just personally, really interesting stuff to know, just a lot of work. One was compiling data regarding the predatory offender registration system and who's on it, and just there's just because the system was designed for a purpose of kind of catching bad guys, if you'll excuse the expression, and not collecting data about catching bad guys. There's some deficiencies there data wise, and people have questions, and the questions are not answerable. So that bill would have really put a lot of responsibilities and expensive responsibilities, as it turned out, and that may be why the bill isn't advancing any farther. The other bill that you have in front of you, file 3220, Senate file 3222. You have the 1A and 2A amendments. Now, the reason why we're giving them to you in form of amendments is because that bill, while both of those amendments did pass committee, the bill was not adopted at that time because it was going to be laid over for possible inclusion in an omnibus bill. I haven't seen the omnibus bill in which that is included, and it's possible that because it is a lot of work for us and possibly other agencies, it was too expensive to do this year. And it certainly wasn't our intent to kill a bill by giving it a big price tag, but it's a lot of work that's encompassed in this bill. It's a lot of data. Again, it's a similar problem. Policymakers want to know data, and they just found when they tried digging into particularly pretrial conditions and bail and those sort of things. There wasn't a lot of data. So this bill would essentially make the Minnesota Judicial Branch and then ultimately the Minnesota Sentencing Guidelines Commission sort of repositories and analyzers of all this data. And it really goes beyond just pretrial data. And you can see all that in your bill. I'm not going to get into all that, but it would be a lot of work. It would be exciting work, frankly, but it would be really changing the mission of the commission and particularly the commission staff. So I just wanted to share that with you. I don't have an update as to whether that really has any legs this session, but that's super interesting. The other bill I wanted to bring to your attention was House File 3614, which is a public safety policy bill in the House, and that did pass the House floor. So that's been sent to the Senate. So this is actually, the House is done with this unless, of course, the Senate doesn't agree with it word for word, and then it has to go to conference committee. But you may recall that you made 7 recommendations to the legislature that we reported in the report to the legislature. This bill adopts 4 of those recommendations, so that's exciting. There's a standalone bill that was passed by the House that's also been sent to the Senate that adopts the 5th recommendation. So there's only 2 recommendations, and I haven't seen anything on those, so I don't think those are necessarily going to pass. One of them has to do with it was a little bit vague recommendation. It was basically the law involving deprivation of a vulnerable adult was broken. At least that's my assessment of it. It's broken. The elements of the crime do not match the penalties for the crime, and it needs to be fixed. And that's what we told the legislature, basically, here, fix this. And they, I don't think, have the time to deal with it. So maybe we'll discuss that after the session's over as to whether we can be more helpful or somebody else can be more helpful with respect to that. And the other one had to do with data and record keeping on life sentences for premeditated murder of an unborn child, and that's not going anywhere. So that's about that. And then just a couple of other things that I mentioned. So far, no real felonies that are advancing. I mean, you saw the sale of the calcified human remains is in the House bill. There's also some firearms bills that we might see, but I'm expecting our June meeting might not be as crazy as we've had in some recent years where there's just been a ton of new legislation that the commission's had to consider and rank. We may have a few new offenses, but I don't think it'll be overwhelming. I'm sure we'll have something, but it won't be as overwhelming as we might have seen in recent years. That concludes my report, Madam Chair. So I guess we were okay with your time.
Yeah. Any questions for Director Rice? Okay. And we'll move on to public comment.
All right. So members of the public, if looks like you're all on by computer. So if you would like to make any comments, please raise your hand. You should be able to see a hand raising button somewhere on the device or computer that you're accessing this meeting by. And if you would like to make a comment, now would be a good time. All right, I'm not seeing any hands raised. All right, going once, going twice. All right, Madam Chair, it doesn't appear that any members of the public present wish to make a comment.
All right. All right, that actually brings us to the end of our agenda. Anything else we need to discuss or take up today? Hearing none, the meeting is adjourned and we will see you in May.
Excellent.
Thank you.